Stock options are a common form of compensation in our economy. Whether they will be divided in the action for divorce depends upon when those stock options were granted and the reason for the grant. Sometimes the stock options are granted to retain an employee. Sometimes they're granted in lieu of a bonus. Sometimes they are granted to get an employee to come to work for a particular company. So when they're granted is important because if stock options are granted after the date of commencement, but while the action is still pending, if they're granted to retain the employee, they're likely to be post-action separate property. If they're granted as a bonus for work that was undertaken before the action for divorce was commenced, well then the other spouse has a good claim that they're in lieu of wages and that they ought to be considered by the court and divided as a marital asset. Whether the options have vested or not is irrelevant to whether or not they will be divided. The question will be when were they granted and why were they granted and are they marital property?